Who gets the dog in the divorce? Legal ownership. The first question in determining who gets the dog is who legally owns it. If one party purchased the dog or received it as a gift before the marriage, that person may have a stronger claim to the pet. If the dog was acquired during the marriage, the pet may be considered marital property, subject to division along with other assets. In that case, the court may consider who is the primary caregiver or who has the stronger bond with the animal. Primary caregiver. Courts sometimes consider who has been the dog's primary caregiver. This could include who takes the dog to the vet, who feeds it, walks it, and spends the most time with it. If one spouse has been the main caretaker, that could influence the decision. Children's best interests. If the dog is primarily the children's companion, the court may consider the emotional impact of separating the dog from the children. In some cases, the pet may be awarded to the parent who will have primary custody of the children to avoid disrupting the children's emotional well-being. In some cases, the spouses can reach an agreement on who keeps the dog without court involvement. This might happen during negotiations or mediation. If both spouses can agree, the court will typically honor that decision. Jurisdiction and laws regarding pets. The way pets are treated in divorce cases varies by state or country. In some places, pets are treated like property, with the court simply dividing the pet as an asset. In others, some jurisdictions are more sympathetic and may take a more compassionate approach, considering the emotional bond between the pet and the owners. Some places are slowly starting to recognize pets as more than just property, especially in divorce cases. For example, some courts now allow for shared custody of pets in some jurisdictions, where both parties might retain some rights to the dog and work out visitation schedules. Emotional attachment and requests. If one spouse has a significant emotional attachment to the dog, they may ask the court to consider this in the decision. However, this is less likely to weigh as heavily as the other legal factors unless the court is in a jurisdiction that takes emotional attachment into account. Why does it matter who gets the dog? Emotional bonds. Many people view their pets as family members, and the emotional bond can be a significant factor in the dispute. This can be especially true if children are involved, as the pet may be a source of comfort and stability during a turbulent time. Care and responsibility. The court may look at who has the ability to provide a stable environment for the pet. If one spouse has a better living situation, like a yard for the dog to run in, that could influence the decision. Legal precedents. If there is no clear ownership or caregiving history, the court will default to laws about property division. In contested divorces, the decision may come down to other factors like who has the ability to provide for the pet's needs. Final thoughts. While the laws governing who gets the dog in a divorce are still evolving, in most cases, pets are treated like property. The determining factor is often ownership, care, and other logistical concerns. However, increasingly, courts are recognizing the importance of pets to people's emotional lives and considering those bonds when making decisions. It's always a good idea to consult with a family law attorney who can help navigate the specific laws in your jurisdiction and advise you on how best to proceed in your case.